back to the show. This is The Law Show on CL 650.
If I had $1 million, well, I'd buy you a house.
I'd buy you a house. You could buy a house. Depends what kind of condition the house is in these days. We're talking about wills and estates, and we referenced earlier, when that song was written 20 years ago, I think maybe even more than 20 years ago, $1 million was a pile of money.
Absolutely.
And now, as you mentioned, the estates can be $3 million. You get the $1.5 million house and $1.5 million in insurance. That's $3 million.
Yep.
And
so it climbs very quickly with today's real estate market.
So we have Alyssa Lockhart here from McQuarrie Hunter and Leah Donaldson talking about wills and estates. And we touched on children before the break. Now we're getting into powers of attorney. Now, this is more for spouse to spouse, right?
Yeah. If we wanted to talk about powers of attorney, there'd be several reasons that you might appoint someone a power of attorney over a narrow issue. If my husband and I were going on a vacation and we'd listed our property for sale, I might leave Leah the power of attorney to deal with that specific asset over a short period of time.
So you can write that for 30 days and just say that's it?
Absolutely.
Okay.
Or a specific subject. For the most part, though, today we're talking about husband and wife powers of attorney. And for me, in my practice, I don't see a lot of clients who are picking and choosing between documents for price concerns or time constraint concerns. But if a person were to be concerned about how to put an estate plan together as a solid investment in the future, I would highly recommend starting with the power of attorney. If you become incapacitated suddenly without a power of attorney, any number of things can happen, but it will be incredibly more expensive than setting up a power of attorney. If you pass away suddenly without a will, it might not be that your wishes are followed, but we do know what will happen. There will be certainty under the Wills, Estate, Succession Act.
There's steps for that.
There's
right?
steps for that, but there are not steps for what happens if I slip and fall on the stairs at work and I hit my head. What happens if I go in for routine surgery and I have an allergic reaction to medication? What happens if someone runs a red light on the way home and I'm just in the wrong place at the wrong time? If you become incapacitated without passing away, your will does not kick in. Mm-hmm. A power of attorney leaves an individual capable of accessing your assets for your benefit. So will this person be able to pay my bills? Yes. Will this person be able to renew my insurance? Yes. Sell my house so that I can, to facilitate a downsizing? Yes. So if, for instance, my husband and I don't have back-to-back mutual powers of attorney and I become incapacitated, we live in a 3-story home. What if I no longer can handle stairs? I can come home to live and I'm great. I'm happy to be around the family. It doesn't agitate me, but I'm not capable of managing my legal affairs, so I can't sign the transfer papers on the house. I can't help him sell the house. So now he needs a committeeship, and that's where someone like Leah would step in.
Yeah, and that process...
Just to jump in. Mm-hmm. So even though you're both co-own the home, mm-hmm. you still need the power of attorney because you're trying to sign over something that's half of yours, right? Is that basically what you're saying?
Well, exactly, because how would it be if my husband is not incapacitated right now, but what if I decided that somebody that I met this morning looked way better than him? I might just go and try and sell the house out from under him or transfer the property and say he's incapacitated and I'm acting in his best interest, but really I'm absconding with all of my assets. That's an exaggerated example, of course, and we wouldn't see that, but the protection is that when you own property, it is your signature that we require. We require your decision-making power to be exercised in divesting yourself of that property.
Okay, now over to Leah in that situation where you don't have the power of attorney and somebody isn't able to sign over to downsize the house to get a one-level apartment, for example.
So then you're required to go through the committeeship process, which is appointing a committee. And that process requires you to file something with the court, a petition, giving everybody notice that might want to be the committee, and that includes, say, sometimes siblings, other family members, giving them notice. You also have to obtain 2 affidavits from doctors who go and speak to the patient or interview them to determine that you, in fact, are not capable of managing your affairs. So there's checks and balances in place. You also have to serve the government, the public guardian and trustee, with those documents, and they have the ability to provide a response about whether they think that you're the appropriate person.
This sounds like it takes time.
It does take a lot of time, and it's not cheap. So if you had simply had a power of attorney in place, that process is not required. But if you don't, then your family members are left with, say it's an unmarried sister. Well, I might want to apply to take control of her affairs, but my other sibling doesn't think I would do a good job. Well, then it's a contested committeeship, and you can be in court for months, and the legal fees are very high in applications like that.
So I'm guessing anybody that's age of majority should have a power of attorney, right?
Yeah, and some people will say, I don't own land, I don't own a home, I don't need a power of attorney. But you may have a car. I've had clients come in and say, this car has been on my property uninsured for 3 years and I can't get rid of it. The scrapyard won't take it. I can't sell it legally. And it really is the lack of the power of attorney and the prohibitive cost of obtaining a committeeship for such a small, what we would call the estate during the person's lifetime. It just doesn't make sense for the parents to go and get a committeeship if they're being treated as a guardian, if the health care for that no longer minor but incapacitated young adult is being managed carefully. The committeeship isn't always worth the money that it should be spent on it.
So is there an age that you should consider here, that somebody is younger than you typically that should have your power of attorney if something were to happen to you?
Not necessarily. We definitely would want someone who is likely to maintain capacity for the duration of your incapacity. So if we have spouses who are aging, we'll usually nominate one another still as our power of attorney of choice, but we will then have an alternate named in the document so that in the event that I become incapacitated and my elderly spouse also becomes incapacitated, then one of our children or one of our younger siblings or a trusted family friend can step in.
So how far down can that go? Can you name 2 or 3 people?
You can. You can go down as long as you have paper. You could name and name and name.
I know
the
legal documents are longer. Why are legal papers longer than regular paper? Why is that?
Oh, we fill it with lots of grammatical. We stuff it with words. No. I think that for me, I would occasionally go down 2 levels. But realistically, if you have named someone who is likely to maintain capacity for the duration of your incapacity and something untoward would have to happen to them, that's so rare that the alternate would be sufficient. But occasionally we see another alternate.
Are there any other kinds of powers of attorney? Is there any other form of this? Or different kinds of things? Well,
a power of attorney essentially authorizes somebody to transact business utilizing your assets for your business, or for your benefit, I should say, sorry. We have representation agreements where that allows somebody to give instruction to your physicians and your medical team in the event that you're not capable of directing your own medical care.
So I think that's where the confusion lies, is people think that a power of attorney gives the spouse the right to act on your behalf if you're incapacitated in hospital, like do not resuscitate, something like that.
Exactly. A representation agreement is like a power of attorney over the body, if you wanted to characterize it in that way. But it is a separate document. There's separate legislation that covers that. Maybe, Leah, do you want to talk about who stands in stead of a patient if they don't have a representation agreement?
Yeah, so the same process would apply. So in committeeships, the actual committeeship is split between committeeship of estate, which is basically finances, so that's the power of attorney document, and then also over their person or their body, and that's the medical side of things. And occasionally we see circumstances where one person, say, wants to take control of the person or their medical needs, and the other party doesn't have any interest in that. They just want to control their finances. And so in terms terms of conflict between contested commentayships, that's an issue that people have to deal with as well.
Okay, so that must take time, and that is where you need time. Sorry, it takes time, but sometimes you need to act.
Time.
I don't have time, exactly. Thanks, you should be hosting the show. and medical problems need to be dealt with right away.
Yes, sometimes they're urgent. So that's why it is not an ideal situation to have to go and get that commentatorship order. It's much easier and clearer if you've done the planning in advance.
So in a situation where you have somebody who's in hospital and they're not conscious, so do you have to actually take that to the hospital? Do you know how that works?
Mm-hmm. So with the representation agreement, the individual who's named as your representative essentially stands instead of you to direct your medical team, and they will take that document to the hospital. There is a NIDIS registry. It can be registered so that if I'm in a traumatic accident, it might be something that the trauma team searches on my admittance to the hospital. Mm-hmm. Oh, this is fine. We'll call Alyssa's husband. This is his cell phone number.
Well, that's good
registered.
that there's a registry there.
There is a registry. Not everybody relies on the registry. The other question is whether this document will be searchable in the registry in other jurisdictions, which is clearly a concern, and that's not the case that it can be. So registering is great if you have an event where it is searchable.
And in British Columbia versus being in Texas or something, right?
Exactly. So the other question is, will the document be recognized for its full legal force if you're traveling in Athens and you have an accident? So there are jurisdictional questions, but ultimately we spend most of our lives close to home, and it's a document that is intended to protect us for those purposes primarily. It is very informative to foreign jurisdictions. But yeah, you take it to the hospital and you say, look, I am the person that this individual chose. And really, one thing that I tell clients over and over with respect to the representation agreement is it's not absolutely necessary, although it is advisable, that you pick someone just because they have good judgment. I mean, I would never pick someone that I didn't think had good judgment, but more so, is this person someone who knows your judgment? Mm-hmm. Because this is your body. And
your values.
And your values. I want them to park their judgment at the door and walk into my care room and use my judgment over my body. So it's very important to have the conversation with, if it's your spouse or if it's your child. Not everybody agrees on long-term care or end-of-life care. You know, I talk a lot. My husband says that if I became incapacitated, he is my representative. He would sign me up to be, a Walmart greeter. He would never keep me in the house and talking to him all day. So this is a person who not only will make a decision about end-of-life care, which is what clients predominantly see this document serving, that purpose, but it'll be somebody who says, what care facility should this person reside in? Are we able to force this person to undergo certain medical procedures despite their objections at the time? What if they're wandering? Can we restrain them? Should we enroll them in programs, rehabilitative programs, so occupational therapy? Should they have a job, or do we consider that dangerous to them or just unimportant? Maybe they should enroll in art courses. What will be paid for them? There's a lot that goes into the healthcare decision making, because more and more as our medical teams advance in what they're able to do for us, we're living with incapacity for longer periods of time.
Yeah, a lot of people say to themselves, it's quality of life.
Exactly.
I might be here, but I'm not, it's not a good quality of life.
Right. So that person will be there to manage the quality of life, and at the point where the quality of life is so diminished that we want to make the harder decisions, we want them to know what our decisions would have been.
We're going to take a quick break, and we're going to continue our conversation about wills and estates next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.